Thank you, Elaine, and welcome all of you. Thank you for joining us for this call. This is about holding people accountable, the professionals and alienators and their enablers, holding them accountable and suing for damages. Before we go on, I would like to say that neither this presentation nor what the facts or cases I refer to are meant to be legal advice. Each case or legal controversy is dependent upon its unique facts and circumstances and applicable law in your jurisdiction. So while I'm going to discuss some cases and some fact patterns, my opinion is based upon my experience in litigating parental alienation cases and representing targeted parents in courts all over America and internationally. The cases that I discuss are ones where I may have been involved in as a lawyer or as a consultant, or there could be cases which are in the public domain and I have not had any involvement, but just found useful to be for the purposes of illustrations. But the fact that these cases were decided at some point in time does not mean that in and of itself they could be useful to your fact pattern or your case. It's important to consult with your lawyer and to learn the law in your jurisdiction. The other thing that I mentioned to Elaine earlier is that I will be happy to prepare an executive summary of today's presentation and circulate amongst all the attendees. I will be giving Elaine my notes in the next week so that you all can just sit back, relax, and not worry about taking notes. You don't need to write down about cases. You don't need to write down particular citations. You will get a summary in an email, and then you can share that with your lawyer or your consultants, and if it helps you, more power to you. Great. I've received numerous questions, about 100 or more, for my presentation today. And I have found these questions to be very well thought of, extremely relevant, and unfortunately all too common. Thank you for asking these questions. I will try to incorporate most of the questions in my presentation as we go forward. Asking a question is the first step towards transparency and accountability, something that we desperately need in family law and family courts. And that's what we're going to talk about today. The concept of parental alienation is not new, nor it is novel. People often talk about how this is a newfangled concept and just have come out recently, and so-and-so judge or so-and-so courts don't seem to believe in it. Well, if we look at the case law, if we look at the judicial decisions that we have for the past several years, going back to 2 centuries back, the English-speaking jurisdictions have grappled with the concept of alienation for more than 200 years. We have cases from England and from United States going back 2 centuries, where the courts have discussed the concept of alienation. They might not have used the term parental alienation, much less the term parental alienation syndrome, but they have talked about alienation of affections. They've talked about how children could be manipulated by a parent or a third party. They've talked about how alienation can take place through indoctrination. So it's certainly not a new concept. Coming back to American courts, we have dealt with the term parental alienation and parental alienation syndrome in child custody cases since Dr. Richard Gardner's early formulation of the concept in the 80s. And if we look at the study done by Dr. Demosthenes Larandos, Dr. Larandos in his recent book that he published with his co-editor, Dr. William Burnett, talks about his research project where he did a research of the terms alienation, parental alienation, and its variants thereof from 1985 to 2018. And he came across thousands of cases where the courts have accepted the terminology, where the courts spoke about alienation, where there was testimony given about alienation and findings made regarding parental alienation. So it's certainly not a newfangled concept. It's certainly not a new theory. This theory has been alive and kicking in American courts for quite some time. But despite this, the relief is difficult. We still have to struggle to make the judges understand what alienation is about. Targeted parents still have to struggle with the lawyers who often tell them that so-and-so judge will just simply not hear about it or doesn't seem to believe in it. And why is this so difficult? In my opinion, it's difficult for a number of reasons. First of all, there is a lot of talk about quote-unquote corruption in the family courts. Social media postings are full of it. You see articles in newspapers or journals about corruption in the family courts and whatnot. I don't buy it. I don't think that there exists corruption in a legal sense in family courts. There might be few esoteric incidents, few rogue actors here, but on the whole, it's not the case that the family court is corrupt and it's just simply out to take the children away from the parents. Rather, I believe in what's called the Hanlon's razor, the maxim put forward by Robert Hanlon, which is never attribute to malice that which is adequately explained by ignorance or incompetence. I have not found judges to be cruel or corrupt on a broad sense. Despite the peer-reviewed professional literature on parental alienation and despite all the books that are out there on alienation, and despite the judicial decisions on parental alienation coming out from across the country, there still continues to be a shocking level of ignorance on PA and ignorance on how to handle these cases. And we need to ask a question, why is that? And one of the big reasons why targeted parents fail to get proper court intervention is because of the lawyers. And that's where the first step of accountability comes in. Family court lawyers, the lawyers who represent targeted parents in courts, the lawyers who represent the children, the lawyers who function as guardians ad litem, minors counsel, lawyers, guardians ad litem. All these lawyers have a huge responsibility, and they need to discharge that responsibility with competence. I learned this from Dr. Stephen Miller, who is very gracious with his time and very generous with his knowledge. I have found him to be immensely helpful to understand the concepts of science, to understand how it works, to understand the research. And some time ago, Dr. Miller told me and explained to me how it is a mistake to think like a lawyer when handling a case of parental alienation. And not just a mistake, a catastrophic mistake at that. About a year ago, Dr. Miller and I gave a presentation on this topic in Philadelphia to a room full of lawyers and targeted parents and judges as well. And here's where it comes into play. Typically, family law lawyers use their professional intuition, for a lack of a better word, the gut feeling. And the reasoning goes as forth: I have been practicing law for the past 30 years, and I know what to do. I have done hundreds of divorce cases, and I know exactly what needs to be done. On the face of it, appears to be a high conflict case. The mom or dad is screaming for help. The kids don't want to see the targeted parent. The other parent is actively alienating the kids. It's a bad situation. Let's all go to therapy. Well, let's have a cooling off period. Take a breath. And these suggestions, well-meaning though they may be, are disastrous in cases of parental alienation. Lawyers end up giving parenting advice instead of doing the job in the court. I have found time and again, by the time I enter a case which has been going on for some years, and a targeted parent is supremely frustrated for repeated violations of parenting time, for repeated violations of court orders, for the children being defiant, rude, disrespectful, and all that the professionals are doing, including their own lawyers, is to point fingers at them and ask questions about what's wrong with them. And they mistake the reaction to the alienating behaviors and the reaction to alienation. They conflate that with causation. It's not a lawyer's job to give parenting advice, especially to a targeted parent who is caught in the clutches of alienation. Lawyers apparently find every excuse in the book to avoid a trial. They mean well, perhaps. They want to practice collaborative law. They want to go to mediation. They want to settle the case. And divorce lawyers especially are not, generally speaking, trained trial lawyers, which means that they will try to get a settlement out of the court. And it works well in cases that do not involve parental alienation. In fact, it's commendable, and there should be no waste of resources for going to trial or going to litigation when you can settle a case. But it doesn't happen in the case of alienation. You can't expect to hold hands and sing Kumbaya with an alienator. You can't expect to reason with an alienator. And the more time that goes by into these efforts which are made, which are supremely wasteful, both in terms of time, effort, and money, time is number one enemy. And before you know it, you have months that have gone by. The situation has got from bad to worse, and the judge doesn't have a clue. There have been many cases where the litigation dockets are full of motion filing, where motions are filed after again and again and again. Attorneys bill for all the motion filing. The guardian ad litem is on the case as well. The minor's counsel is on the case. The therapist is on the case. There are motions from all around, but there is never a hearing. Lawyers go to court, they meet in the hallway, they reach a settlement, they make an agreement, and they come back and tell the targeted parent, this is going to work, we are going to make this work, and before you know it, the deal falls apart. The other big issue is the refusal or failure of lawyers to make a proper record. They engage in pointless motion filing, but there is no appropriate record which you can take to the Court of Appeals, if necessary, to get the trial judge or trial court overturned. You find case after case where the lawyers go back into the chambers. Nothing that is said in the chambers makes it on the record. It's not part of the record. There is no record made of what was said or not said in the chambers. The appellate courts have no record to review. But it's a matter of practice. It happens all across the country, and targeted parents get supremely frustrated because they are left out. They don't know what was said on their behalf in the chambers. They don't know what the judge was educated about. So if your lawyer tells you that there's going to be a chamber conference and he or she needs to go into the chambers because it's to your advantage, ask that he or she memorialize everything that was said in the chambers, put it on a letterhead, and give it to you. That way you have an account by your lawyer in writing of what allegedly happened in the chambers. But the surest way to get remedy is to go to a trial. Get to trial. Get an evidentiary hearing. Apart from an evidentiary hearing, everything else is simply a matter of allegations, opinions, and what matters at the trial are facts. Facts, facts, and facts. The fact that you file a motion screaming parental alienation doesn't mean anything from a legal point of view. It's simply an allegation, and most of the time it's unsupported allegation. The only way you can get intervention is to demonstrate to the court by presenting evidence, not just allegations, not opinions, but evidence of allegation through expert testimony or otherwise. And that's the only way to get intervention. But accountability is a two-way street. In the words of Jerry Colonna, one of the renowned executive coaches to the CEOs, it is important to ask ourselves, how have I, the targeted parent, been complicit in creating the conditions I say I don't want? Ask yourself, what diligence did you do before picking a lawyer? Think about it. Even today, those of you who are fighting these cases in the courts, ask your lawyer if he or she can explain to you the difference between parental alienation and parental alienation syndrome. Ask your lawyer if he or she can tell you what empirical evidence supports the theory of alienation. Ask your lawyer if there is any difference between traditional psychotherapy and reunification, and if so, what is it? Ask him or her what are the effective interventions, both legal and mental health, in cases of moderate to severe parental alienation. Are there any success outcome studies of programs that are focused on remedying parental alienation? If your lawyer doesn't understand this topic, if your lawyer doesn't understand parental alienation inside and out, what hope does he or she have to pursue it a fact finder, a judge, or in some instances a jury? No doubt your lawyers may resent being put on the spot. No doubt they may resent trying to justify as to why they deserve to have your case and represent you. But at the end of the day, it's your life, and these are your children on the stake. Do your diligence, and if there are red flags at the beginning of a relationship, lack of knowledge on the part of the lawyer, refusal to communicate timely, refusal to go to the court, don't expect that the things are somehow going to get better miraculously. They probably won't. And to expect otherwise is to engage in delusional thinking. It's not impossible to prove a case of parental alienation in a court of law. Many lawyers have done that. I have done it several times. And there are court opinions available from different courts from around the country where the courts have made a finding of parental alienation. It's a myth that a particular judge or a particular jurisdiction doesn't, quote unquote, believe in parental alienation. In this day and age, that would be saying that a judge doesn't believe in science. No one would accept for a moment that a judge in a particular jurisdiction doesn't really believe in domestic violence. Why would you accept that? Some of you ask a question that your lawyer won't do this or won't do that, or your lawyer tells you that a particular judge is simply not going to accept the theory of parental alienation, doesn't like it. Well, too bad. I think that lawyer is mistaken. In my entire practice, through the past 2 decades, around the courts in America, all different jurisdictions, I have never come across a judge who has said to me that he or she refuses to believe in parental alienation, that they refuse that the theory of parental alienation doesn't exist, or they simply won't accept that argument. They might have disagreed with me. They might have refused to accept the finding of parental alienation. They might have refused to make a finding of parental alienation, but never have they ever said that they refuse to believe in the concept of parental alienation. Some might have expressed skepticism. Some might have expressed some doubt, and it's mainly because they don't know better. They don't know the difference between alienation and parental alienation syndrome, or perhaps they are vulnerable or susceptible to the propaganda of misinformation out there, but they are willing to learn. So when your lawyer tells you that so-and-so jurisdiction or so-and-so judge is not going to accept the theory of parental alienation, that's a red flag. And that's when you ask for accountability. Ask questions. If necessary, change the lawyer. Ask the lawyer to put that in writing, in a legal opinion. When we speak of accountability, we are not simply talking about filing lawsuits against professionals such as judges, therapists, lawyers, guardians ad litem, and others. That very well could be an option, but there are other less aggressive ways to send the message and hold people accountable. After all, the targeted parent's primary goal is to save the relationship with their child, not to get rich or make money out of the horrific situation. So let's sit back and think about the spectrum of remedies or options that we have. If you can visualize a spectrum, on the left hand, let's say from the left-hand corner, we start with less aggressive remedies, such as education and making a record in the court and educating your fact finder, the judge. And on the extreme right corner, the most aggressive remedy possible, which could be a lawsuit against the lawyers, judges, therapists in a state or a federal court for money damages. So we have a range of options, and they run the gamut of just plain vanilla litigation, trying to educate the court by going to a trial and trying to prove your case, to all the way to holding them accountable and making them pay monetary damages for the harm that they have done. Let's start with the therapists. Mental health professionals or therapists who do court-appointed or court-involved work yield tremendous power. And with this power comes responsibility. Therapists, depending upon their education, training, and professional affiliation, are governed by ethical principles and code of conduct. For instance, a psychologist would be governed by the American Psychological Association's Ethical Principles and Code of Conduct 2002, and the relevant state's public health code, and the licensing board's regulations, which enforces the ethical codes of conduct. A social worker would have a similar code of conduct promulgated by National Association of Social Workers together with the state counterpart. And similarly, other professionals such as licensed marriage and family therapists and others would have their own codes of conduct. A therapist is duty-bound to follow these rules, regardless of whether his or her actions have been blessed by or approved by a family court. Many lawyers will continue to complain to a magistrate or a judge about a therapist's actions, but will fail to take action and do what matters, which is to file a complaint with the licensing board, to hold them accountable, to seek disciplinary actions, sanctions. Complaining about a court-appointed or court-involved therapist to a family judge doesn't do you much good. You're barking up the wrong tree. A judge doesn't really understand the codes of conduct applicable to a therapist. It's not the judge's domain or his place to decide whether a particular therapist has violated the ethical codes of conduct that are applicable to his practice. And all you're going to do is to get the judge frustrated and not get a result. Instead, if there is a violation of code of conduct, if the therapist is doing something that is flagrantly unethical, the proper course of action would be to file a licensing complaint. Have the lawyer write a letter to the employer of the therapist, put them on notice to preserve all the records, preserve all the evidence, and to memorialize every violation that the therapist has done. Let's go through some common scenarios. One of the most common scenarios that comes up in the cases of alienation is the informed consent agreement violation. When doing court-involved therapy, such as joint therapy, in many cases, the judge will order the targeted parent to go to therapy with their kids. Or there is already a joint therapy in place that is court-approved or somehow blessed by the court. And in such situations, the targeted parent, dad or mom, will go to therapy with the kids or counseling, and the therapist will try to repair the relationship and work on it. And in these situations, the therapist will ask the targeted parent to sign a statement setting out patient rights or some sort of informed consent agreement. Psychologists are expected to obtain informed consent from patients and parents of minor children at the outset of the treatment, before beginning the treatment. Pay close attention to this document. Look at what's being promised to you. Read it carefully and make sure you have a copy. In some situations, it's not unusual to find instances of a therapist who begins working with a targeted parent and the children and then stops. Let's say we have a situation where mom goes to joint counseling or joint therapy with the kids. The therapist begins work. There's an informed consent form signed by the mother. And after a few sessions, the children just keep on repeating the same complaints against the mother. Mom is mean. Mom yells at us. Mom doesn't listen to us. We are afraid of her. We are scared of her. We don't want to go to see her. She is never going to understand us. We love dad. We want to stay with dad. And on and on and on. And the mother who is caught in this situation is simply reacting badly to the children's defiance and children's rejection. And the therapist feels that somehow the mother is not validating the children's reality. And the therapist decides to stop the mother's participation. The mother is kept out, and the kids continue to see the therapist and continue to spin the tales of their imagination. And that's wrong. Under the legal and ethical requirements of informed consent, a therapist may not, on his own, change the treatment plan or alter the nature and goals of the treatment without consent from the patient or the patient's legal representative if the patient happens to be minor. A therapist cannot unilaterally stop the mother's participation and from joint sessions all of a sudden start just seeing the children alone. That's the change of role. If the sessions are not going well, the therapist should discuss with the targeted parent to discuss options and offer suggestions, not make unilateral changes. Doing so could very well make the therapist face a disciplinary action. The other issue that comes up concerns record keeping. In some cases, when I subpoena a therapist's file, records of the therapist and notes of the therapist, it's not unusual to find absolutely no record of the therapist obtaining informed consent regarding the treatment or plan or treatment goals. A therapist is obligated under the ethical principles and code of conduct to document the treatment plans, document therapeutic interventions, progress in treatment, all as part of their record-keeping duties. And not doing so is a violation of the code of conduct. Several of you asked a question about how do we get these notes? Our lawyer tells us that we can't get the therapist's notes, that asking for this note is somehow going to get the judge angry or the therapist angry, and they won't just give it to us. First of all, if there is court-ordered therapy, there is no expectancy of confidentiality. A court-ordered therapist is duty-bound to report to the court about the progress made in therapy. They have a goal in place. They have to report to someone as to how they are progressing towards that goal. If the targeted parent is a participant and a patient, obviously they can sign the release to get the records. In some jurisdictions, depending on the ages of the children, the child may elect not to release the records concerning the child's therapy. But even so, this privilege is never absolute. It's always relative and it's always qualified. And this privilege must yield to the well-being of the children and to the best interests of the children. The argument to be made is transparency and accountability. And when fighting for these records, first of all, in many jurisdictions, there's a statutory right given to a parent to get copies of their child's medical and psychological records. A biological parent has a statutory right to obtain these records. But let's say your lawyer sends a subpoena out and you run into a roadblock and the therapist or the other side's lawyer files a motion to quash and you end up before a judge. And the usual argument made against the targeted parent is that they are going to use the records as a fishing expedition. The child is going to be embarrassed about it. We can't reveal the confidences. It's going to defeat the purpose of therapy, and so on and on. And the argument to be made to the judge is that we believe that the therapist has been violating the ethical rules of principles and codes of conduct. We believe that the fact that the child keeps on repeating the same complaints again and again in therapy, which have no basis in reality, demonstrates cognitive distortions here. They demonstrate that the child is being indoctrinated, has been manipulated, and these complaints have no basis in reality. and this therapy is not going to work. In fact, it's doing more harm than good. Sometimes you can ask for an in-camera inspection of these records so the judge can look at it and decide. A better course of action, because most judges have no background in science, they have no background in mental health issues, and it would do you no good to have the judge look at the therapy records to try to decipher what exactly are you looking for. But you can have another mental health expert, a psychiatrist or a psychologist or an MD as your expert, and ask that these files be provided to your expert, who is also a licensed mental health professional, so that your expert can review what's going on, and there can be assurance of transparency and accountability. And most judges will go for that. But you need to lay the groundwork, not just accept your lawyer's knee-jerk answer that a judge won't like it and the therapist is not going to do more work, or let's just not ask for this. Getting the documents and getting the records often is one of the most critical things to do in a case of alienation, because it demonstrates the children's disconnect with reality. And it allows you to go back to the court and ask for proper relief, which is not traditional psychotherapy, but a specialized program that is designed to remedy alienation and not make a bad case far worse. Another issue that comes up amongst therapists is uncritical listening and simply documenting what the child says. And this is why the notes are important, because they may reveal that a therapist's quote-unquote therapy simply consists of listening uncritically to the alienated child's complaints, where they are critical of the targeted parent. For instance, a child may go to therapy and just start regurgitating the facts, so-called facts or past incidents about the father. Let's say the dad is the targeted parent. He was never there, he's mean, he drinks all the time, he's an alcoholic, he beats me, he screams at me, and all in all. And the notes reveal that there is no documentation of therapeutic intervention of any kind. In fact, the entire therapy consists of nothing more than listening sympathetically to the child and documenting uncritically the child's complaints. And if that's all that the therapist is doing in session after session after session, what's the point? A mailman could do the same thing. That's not what therapy is about. If we look at the AFCC's guidelines for court-involved therapy, Guideline 1 talks about how a court-involved therapist should be particularly aware of the possibility that the therapy may support a parent's goals in legal conflict instead of helping the child. And a child or an adolescent who is expressing a position regarding a contested issue, let's say parenting time or custody, may have been subjected to external influences. That's number one guideline that is promulgated by AFCC for a court-involved therapist. A therapist should not, in a court-involved therapy case, take the child's statements at face value, especially when other parent has alleged parental alienation. But you see these cases where the therapy notes consist of child simply bad-mouthing the other parent and the therapist writing it down dutifully again and again and again. Another guideline of AFCC's code 2.6 talks about accountability. A therapist must develop a multifaceted and comprehensive view of the evidence supporting how the family as a whole was functioning. Let's look at the notes. Let's try to find out what did the therapist do to figure out the baseline relationship. The child is complaining about the father being mean and father being cruel and the father doing this and that. Well, did the therapist ask about what was the relationship like before the separation? Are there any efforts which are evident from the notes that the therapist took the trouble to find out what the relationship was from a historical perspective? It's important to know. These notes could be extremely valuable if you are going to depose the therapist or cross-examine the therapist at a trial. They would be also critical for your expert to demonstrate why there exists alienation in this case and why the children's preference for the favored parent or the alienating parent should not be given due weight and preference. Guideline 4.6, potential role conflicts in multiple relationships. When a therapist begins to work with the children of the targeted parent and then stops working with the targeted parent and simply focuses on children, as we talked about in the example that I gave you, that's an example of sequential multiple roles, and that's a conflict. You often see court-involved therapists changing hats. They start by functioning as a therapist, and all of a sudden, before you know it, those who are not that well experienced in court-involved work get triangulated. The alienating parent starts taking the children to the therapist, and the children badmouth the targeted parent, same old complaints, and the alienating parent then tries to triangulate the therapist into writing letters to the protective services, writing letters to the judges, writing letters to lawyers, and then these letters are used in litigation to cut down the parenting time or to suspend the parenting time of the targeted parent. And that's a conflict. That's a conflict because the therapist is now functioning in a forensic role. And that's why the notes are also important to figure out where did the meetings take place, who met whom, for how long. Take a look at the invoices as well. Guideline 10.3, communicating limits and distinctions. If a therapist is writing a letter or a report, communicating with the third parties, such as the court, a guardian ad litem, child protective services, or lawyers, a therapist must distinguish between what the children told him or her and his or her conclusions. They must articulate the limits of the data they rely on. And not doing so is a violation of the guidelines and the rules. So why file a complaint with the licensing board? For several reasons. One, accountability. These professionals hold tremendous power. And unless that power is checked, it can be misused, and it's often misused. But there's also a strategic reason. The licensing board may be willing to investigate the matter and hold the therapist accountable when a family court may not. I've been involved in situations where a judge simply throws up the hands and says it's not his or her job to micromanage therapy. That the so-called therapist, so-and-so therapist is well known in the local area, and the judge is not going to micromanage the therapist's job. On the other hand, the licensing body, when it receives a well-pled complaint laying out the case, will ask the therapist to file an answer. They have to answer it. And they may open an independent investigation, and the answers and the documents given to in response to the complaint are all available through Freedom of Information Act. You can subpoena those. You can get copies of those. And if there's an open investigation, and if the therapist is indeed disciplined or sanctioned for the violations, you can go back to the court and tell the judge that this is exactly what you were complaining about. Now, your complaints, the targeted parents' complaints, have justifications. You are not only speculating some violations of some arcane codes of conduct that the family court may not have a clue about, but now you have a case number, an ongoing active investigation against the therapist. You can use that to pursue with the court to stop the therapy or to pursue another course of action. But if you simply let it go and not take any course of action, not subpoena the notes, not take it to the court, not file a complaint, pretty soon you will have a therapist who is completely triangulated by an alienator. And you will have the alienator, his or her lawyer, the therapist, the guardian ad litem, the minors counsel, all aligned you. And then the judge, reasoning on the professional clinical intuition, will fall back upon the old fallacy and say, well, these all people are complaining about the targeted parent, and they all can be wrong, so something must be wrong with the targeted parent. And that's why it's important to get these notes and to hold the therapist accountable. Let's change gears a little bit. Now, let's talk about the judges. Judges, too, are duty-bound and obligated to follow their applicable canons of judicial conduct. Similar to the therapists who have their own ethical principles and code of conduct, judges have their own canons of judicial conduct. Every state has them. Every jurisdiction, federal or state, has them. And they are all almost on the same lines. There might be a minor difference in between judicial conduct of, let's say, Michigan versus New York, but they are all modeled on the American Bar Association's model of judicial conduct. And it's important to remember that there is a fine line between judicial misconduct and legal error. The appellate courts check the reversible legal errors, and they can reverse a trial judge's decision if they found a legal error. However, it is the Judicial Tenure Commission, not an appellate court, but a separate Judicial Tenure Commission which is responsible for judicial accountability and which checks judicial misconduct and abuse of power. One of the common complaints of targeted parents is a trial judge's failure or refusal to grant them a hearing. It's a common refrain that months have gone by, sometimes years have gone by, but the targeted parent has simply not had his or her day in the court. If the lawyer has done his or her job properly and filed the appropriate motions, court papers, showing proper cause or, in some cases, change of circumstances necessary for the court to grant a hearing, then not granting a hearing or not adjudicating the pending matter may run afoul of the canons of judicial conduct. For instance, Michigan's Canon of Judicial Conduct 3.5, 3 subsection 5, requires a judge to promptly dispose of the business of the court. A judge is required to act in good faith and in diligence. Refusal to follow the law and refusal to enforce existing court orders may violate the canons of judicial conduct. You see time and again where the targeted parents are supremely frustrated because parenting time orders are violated with impunity. These orders are meaningless unless enforced. They are not worth the paper they are printed on if they are not going to be enforced. Because what are you going to do? If you go to the police, they're going to tell you it's a civil matter. Take it with the court. And too often, the targeted parents' attorneys tell them, well, let's just cool down. Let's not file motions for contempt. Let's not file motions for enforcement. You don't want to be the bad guy. The judge is eventually going to see it. The alienating parent is going to shoot himself or herself in the foot. The truth will come out. Just be patient, and on and on and on. And it never happens. The day never comes when the judge wakes up and smells the coffee and realizes, oh my God, there's been a tremendous injustice done here. And I must help the targeted parent. It never happens. Because let's face it, family courts are backlogged with cases. A busy jurisdiction such as Los Angeles, Detroit, Chicago, or any major metro area has thousands and thousands of cases. Divorce, child custody, post-divorce, guardianship, high conflict cases, regular cases, mediation, you name it. And unfortunately, now that the parental alienation has been in vogue and the term has been widely accepted by family courts, the term is in the overkill zone. You will find motions after motions where a parent is alleging parental alienation. Often simple issues regarding a conflict on parenting time, conflict on post-divorce, post-custody matters, or simply inability of parents to go along or make decisions in co-parenting results in allegations of parental alienation. And that has also caused judges to get somewhat desensitized to this concept and roll their eyes. Here comes another case in alleging alienation. So in this situation, it is extremely important that your lawyer files the appropriate court papers. If there are affidavits required under oath to present the facts necessary to get an evidentiary hearing or trial, make sure you do that. But if the papers are filed and the papers are good and they meet the standard and the burden of proof required, then the court must grant you a hearing. Canon 1 of the judicial canons of judicial conduct requires the judge to observe high standards of conduct so that the integrity and independence of the judiciary may be preserved. Canon 2 requires the judge to treat every person fairly with the courtesy and respect. If you see a judge belittle a targeted parent, call the targeted parent names, or jump to conclusions and demonstrate that he or she has prejudged the case from the bench without allowing the parties to present evidence, that may be in violation of the canons of judicial conduct. It may even be evidence of bias. Take a look at the case of In re Gorsica, a Michigan case, 2017, out of Michigan Supreme Court, where a Judicial Tenure Commission took a very strong view of a family judge who was involved in a case of parental alienation and recommended and upheld the public censure of the judge. The Judicial Tenure Commission had recommended suspension for 30 days without pay. The Michigan Supreme Court upheld the public censure of the judge, but found that the suspension was not warranted. It was a very tough case involving alienation and children who were indoctrinated and brainwashed, and a judge who was extremely frustrated with how the case was panning out. And it was a perfect storm. In your summary, I will give you the notes about the case. You can read it at your leisure. But there are cases from around the country where judges have been reprimanded, where judges have been called into question, where the appellate courts and the Judicial Tenure Commission have asked for answers as to why haven't they moved a case, why haven't they held hearings. In many jurisdictions, in fact, the judges have to explain or account for some cases for which progress have been not made to the chief judges or to the higher-ups. But if your lawyer is not pushing for a trial, if the lawyer representing the targeted parent is not filing the appropriate motions and not asking for an evidentiary hearings, then the blame doesn't lie on the judge's shoulders, it lies on the lawyer's shoulders. And it's a mistake in most cases involving parental alienation to think that somehow the case is going to be resolved miraculously by itself, or through mediation, or the children as they grow up are going to realize what's the truth, or with the cessation of litigation, the hostility is going to die down, and somehow things are going to be okay. If you have a case involving alienation and the children are demonstrating signs of alienation, you need a trial. You need to prove your case. Because if you put on a case and you don't win, you're not able to show or make the findings necessary, you can get the appellate courts to intervene. And there are plenty of decisions where the appellate courts have intervened and reversed the trial courts for failure to act on the evidence of alienation. But if you don't get there, if you don't present evidence, if you don't put on a case, there's nothing for an appellate court to review. And valuable time goes by. The other downside is that all of a sudden, you have a new normal. A couple who started out with 50-50 custody, once the alienation sets in and the children have been refusing to see the targeted parent, and the months and months go by, and all of a sudden the trial judge is then told that for the past 20 months of the past 2 years, the parenting time order which was in place was never followed. The kids did not go to parenting time. The targeted parent did not come and seek help. And this is the new normal. And then it's tough to overturn that. So go to a trial. Get an evidentiary hearing. Get the opportunity to present the facts. Not opinions, not allegations. Present the facts of alienation. Let's talk about guardians ad litem, GAL. GALs in family court are extremely important professionals. They hold tremendous power. In some jurisdiction, a guardian ad litem could be a mental health professional, and in some jurisdiction, they could be a legal professionals. For example, in Michigan, it's not necessary that a guardian ad litem has to be an attorney. A judge could appoint a GAL who could be a mental health professional or a social worker or someone else. But no matter who functions as the GAL functions as the arm of the court. He or she is the agent of the court, and their obligation is to primarily assist the court, educate the court, guide the court, and advocate for the best interests of the child for effective interventions. A good GAL can make a lot of difference. They can empower the court. They can give proper research, proper case law, and proper understanding of the alienation dynamics to a court of law. I'm reminded of a case out of Manhattan years ago where I represented the targeted parent, a father, and the guardian ad litem, who was appointed by the court, did a thorough investigation. And the child, as typical as we find in the alienation cases, wanted to stay with the mother, the alienating parent in that case, and made it known to the guardian ad litem in no uncertain terms. I will see my dad for lunches once or twice a week. I don't want any overnights. I don't want any vacation time. I don't want any weekend times, nothing of that sort. No overnights and nothing. And my dad has to pay child support. My dad pays for private tuition. And twice a week, I'll have lunch with my father in a public place, and that's about it. And the GAL did a thorough investigation and wrote a really good brief in the court. And when the time came for a trial, the guardian ad litem properly apprised the court about the minor child's wishes. But having put the wishes before the court, the GAL then went on and educated the court about what parental alienation is and why it would be a mistake to give the child what the child wants or wishes for. Because when you dig deeper, it's not the child who is putting out these wishes or preference. It's an alienating parent's wish coming through, indoctrination and brainwashing of the child. And because of the GAL's strong advocacy and proper investigation, the court actually understood it. And the court gave custody to the father. On the other hand, we often find, and in fact more often than not, we find bad or incompetent guardian ad litems who end up being mouthpieces of alienating parents and alienated children. And these kids, when they get a guardian ad litem who has no clue about parental alienation, who by either blissful ignorance or willful blindness refuse to take a look at the research, refuse to take a look at the judicial opinions on alienation, they end up over-empowering alienated children, kids who are already over-empowered to begin with. And these kids have these GLs on speed dial. And pretty soon, the targeted parent is not even able to parent the child. The mom wants to discipline the kid. Let's say the kid's being defiant, rude, absolutely disrespectful. And the mom says, that's not allowed. You can't talk to me like that. I'm going to ask you to give your phone, go to your room. And before you know it, the kid dials the GAL, sends the text to the GAL. The GAL encourages the kid to call the protective services, call the CPS, call the police, or the GAL calls a targeted parent. You're not supposed to take the phone away. If you do that, I'm going to recommend the judge that he or she suspend your parenting time. And the situation becomes surreal. And these professionals cross boundaries, they go power mad, and some of them end up being personally enmeshed in a child's relationship with other parent. Instead of trying to fight against alienation, and instead of helping the targeted parent repair the relationship, these GALs become so enmeshed with the child that they enable alienation. They make it further entrenched. And in these situations, alienators effectively end up with two lawyers, their own and the guardian ad litem. Take a look at the case Jacob versus Jacob from Michigan 2020, a recent case. In this situation, in this case, a lawyer guardian ad litem was removed from the case by the appellate court. And again, note, it wasn't the trial court that removed the professional. The trial court didn't do it, despite the fact that the targeted parent, the father in that case, repeatedly complained about how the GAL was making the case far worse and was over-empowering the child, was crossing boundaries, was inflaming the flames of alienation. The trial court refused to take action. But ultimately, the matter ended up before the appellate court, and the appellate court was shocked. And in a scathing opinion, it agreed with the father that the GL had become personally enmeshed with the child, had exceeded her boundaries, and instead of assisting the court and helping the court to resolve the parenting time disputes, the professional had inflamed them. The appellate court ordered the trial court to hold an evidentiary hearing promptly to determine whether the lawyer guardian ad litem's fees that the father had contested were reasonable, and removed the GL from the case. In fact, because of the evident bias, the appellate court sent the case to a different judge. There have been cases where I've come in and I've seen the litigation docket run into pages where motions and motions and motions have been filed by all lawyers around, including the GLs, bills running into tens of thousands of dollars, but no hearings having taken place. And it's often just meaningless advocacy where the court, the trial judge, is not even aware of the actual controversies, because simply because you file a motion doesn't mean that the judge is going to read it. They are busy professionals. They have thousands of other cases. If you want your family court judge to give you a trial, it's your lawyer's job to not only file a motion but notice it up for a hearing and to argue it. So if a GL is running amok and you have a rogue professional involved in your case who is ignoring evidence of alienation, who is ignoring the facts, who is ignoring the science, and making a bad situation far worse, that professional has to go. And we are talking about facts, not opinions. A GL can very well disagree with your allegations of alienation. A GL could disagree with the facts. A GL could disagree with the theory. But where it's clear that the facts have no other explanation, there is no finding of abuse, there has been no proven domestic violence, there's been no proven cases of neglect or severely abusive behavior on the part of the targeted parent, the children's complaints are frivolous and have no credence whatsoever, but if the GL continues to simply buy into those theories, then there comes a time when you have to file a motion to discharge the guardian ad litem. And even better would be prevention. Before having a GL appointed on the case, ensure that your lawyer does the diligence. Is the professional experienced in the area of alienation? Has the professional published any articles? Have they attended courses, seminars? Ask about their previous work. Ask if there have been court opinions published about their work. Research them. And if there are concerns about a particular person, it's better to fight them up front and bring it to the court's attention rather than complain about a GL's work, actions, or omissions down the road. Now let's talk about the tort remedies. And when I say tort remedies, I mean filing lawsuits for money damages. In recent years, torts of more general nature have been used by alienated parents to obtain damages and relief, not just from the alienating parents, but also from third parties who have assisted them. And the claims of action, the causes of action that have been put forward are usually intentional infliction of emotional distress, which is IIED, or negligent infliction of emotional distress, is NIED, sometimes defamation. In some jurisdictions which have conspiracy, civil claims allowable, those claims could be made too, or loss of consortium and society of the child. Many of you asked a question about whether lawyers take these cases on a contingency. Contingency cases are those where lawyers get paid out of the winnings. So those are typically the billboards that you see on the freeways as you drive, where you have these big signs of lawyers saying, we don't get paid until we win. And those are personal injury cases, slip and fall, accidents, where there's an insurance company on the other side and some sort of a guarantee of a payday down the road. And generally speaking, contingency lawyers take a percentage out of the winnings once the costs are deducted. Off the top of the winning pile are deducted the costs that the lawyer advances for pay for the third parties, like taking depositions, private investigators, and whatnot. And once those costs are reimbursed, then 1/3 of the winnings are typically go to a lawyer, sometimes more. Unfortunately, to my knowledge, contingency fee agreements are very rare in the alienation situation. In fact, contingency agreements are frowned upon and prohibited in family law and criminal cases in most parts of the country. A lawyer is not allowed to take a case on contingency in a family law arena or a criminal defense category. Now, suing someone for money damages is a tort action. That's not a family law action. And if a lawyer so chooses to, he or she can take that matter on a contingency. But very few lawyers do that, because often we are not talking about deep pockets here. We are talking about suing alienating parents or their enablers. Could be the other grandparents, could be uncles, could be aunts, school teachers. Sometimes state actors could be involved, such as child protective services workers, police officers, if they go beyond the scope of their duties and employment. But most often we are talking about private actors. And because we are not talking about deep pockets of an insurance company or big corporation on the other side, which is likely to settle the case instead of going through a jury trial, the lawyers don't take these cases in a contingency. But you could certainly inquire with a lawyer if he or she takes his cases in a contingency if you would like to. The other question was statute of limitations. That's probably one of the most important decisions or analysis that needs to be made. Whether you have a standing to bring a lawsuit, whether you have a claim that is alive and within the statute of limitations to be brought forward. And they vary. Each jurisdiction has its own statute of limitations. So there is no uniform statute of limitations. Let's say if you could bring a case in Michigan within 2 years of a wrongdoing occurring or coming to your knowledge, the same set of facts could have 1 year or 3 year statute of limitations in different jurisdictions. So it is absolutely essential for your attorney to find out whether you have a valid claim, and if so, what is the deadline for you to file a lawsuit to protect your rights. In some situations, you could have minor children as plaintiffs. If you have custody of the minor children, you could bring a lawsuit on the children's behalf. And in many jurisdictions, the statute of limitations can be tolled until the minor achieves the age of majority and then has a grace period thereafter to bring a lawsuit. For example, a minor suing a therapist for negligence, medical malpractice. So let's talk about the lawsuits entailing the cause of action, intentional infliction of emotional distress. The acronym is IIED. This tort allows a plaintiff to recover money damages for emotional distress resulting from non-tactile tort if the plaintiff alleges and proves by clear and convincing evidence that 1. The wrongdoer's conduct is intentional or reckless. 2. The conduct is outrageous and intolerable. 3. The wrongful conduct and the emotional distress are causally connected. And 4, the resulting distress is severe. So generally speaking, there are 4 separate facts that need to be connected, or 4 separate elements that need to be brought under the umbrella of IIED. Let's take a look at a case, McDermott versus Reynolds, out of Supreme Court of Virginia in 2000. This is a case where they defined what constitutes outrageous or intolerable or even extreme conduct. And the court said that it's never enough to show that a party acted with an intent which is tortious or even criminal, that the party intended to inflict emotional distress, or even that the conduct which has been complained of was done through malice or a degree of aggravation. The court said that the liability does not extend to mere insults, indignities, threats, annoyances, petty oppressions, or hurt feelings. It's just another way to say that the law requires a plaintiff to have thick skin and to be hardened against unkind acts and insults or unflattering opinions. Liability has only been found where the complaint conduct has been so outrageous in character, so extreme in degree as to go beyond all possible decency and to be regarded as atrocious and utterly intolerable in a civilized community. And such a case would be one where an average member of our society, upon learning of the facts, would be aroused with resentment and exclaim, outrageous. That sort of conduct is what falls under the umbrella of IIED. And courts have found alienating behaviors to fit that requirement, to meet that requirement. For example, in the case of Bama versus Bama in Michigan, the father was a psychiatrist who used his training in psychiatry to systematically manipulate, intimidate, indoctrinate, and brainwash the minor children into totally rejecting their mother and to bear hatred against her. And the court found that, well, that could be an example of outrageous conduct. Such conduct would be considered as atrocious and would be utterly intolerable in a civilized society. Take a look at the case Raftery versus Scott, Virginia, 1985, where a federal court was given a case, and the reason the case was in a federal court instead of a state court is because of diversity between the two plaintiffs. What diversity means is that if you have a plaintiff who lives or works in, let's say, state of New York, and the defendant happens to be in the state of, let's say, Virginia. Because of the diversity in the jurisdiction of those parties, they could bring a case in a federal court instead of a state court. So the plaintiff could sue the defendant who lives in Virginia in a federal court in Virginia instead of a state court in Virginia. And there's a jurisdictional requirement that the damages have to be above a certain amount in order to bring a lawsuit in diversity. And the tort here, the claim of action was alienation. And the jury awarded the father thousands of dollars in compensatory damages and in punitive damages, and the alienating parent, the mother in that case, appealed. And the appellate court upheld the jury award. And it held that the harm of deliberate frustration of a close and affectionate relationship between parent and the child did give cause to a viable claim for money damages. But again, these cases are very focused on their particular facts and the jurisdiction. Because 15 years after the Raftery case, Supreme Court of Virginia took up another case in McDermott versus Reynolds in 2000. And here, the Supreme Court of Virginia disagreed with the federal case and the holding. And the Virginia State Court instead looked at the elements of the tort, not the defendant's conduct. And in a different category of case where someone was suing the ex-wife's lover and paramour, not a parent suing the other parent for alienation, the Supreme Court of Virginia said that the ancient tort for alienation of affection was abolished by Virginia's legislature, and therefore such a case could no longer be brought. There's still some sort of debate or controversy whether alienation of affection was limited to cases being brought against other spouses, lovers, or paramours, but not the cases brought by a parent against other for alienation, parental alienation. So that's why it's important to check the jurisdiction, the history of legislation in the jurisdiction, and the history of decisions in that particular jurisdiction before deciding to bring a case. There was another case of Shelter versus Smith in Vermont, where the father maliciously, intentionally, and outrageously inflicted extreme mental suffering and acute distress on the mother by willfully rendering it impossible for any personal contact or communication to take place between the mother and the daughter. The trial court dismissed the complaint, alleging that it failed to state a cause of action. In other words, that, parental alienation doesn't really justify this burden of proof, or doesn't meet the threshold of outrageous conduct. But the Vermont Supreme Court reversed and remanded the matter. And the Supreme Court held that we find the complaint, the lawsuit, adequate. It alleges the 4 elements of the tort necessary to establish the prima facie case: outrageous conduct, done intentionally or with reckless disregard, and resulting in the suffering of extreme emotional distress caused by such outrageous conduct. And the Supreme Court acknowledged that it's a task of the law to remedy wrongs which merit redress even at the expense of incurring a flood of litigation. Because that's a standard refrain. When you sue alienators and their enablers in a court of law for money damages, often a public policy argument is made that, Your Honor, if you allow these lawsuits to come in, we are going to have a flood of litigation. They're going to have all these disgruntled parents who lost in family court and custody and whatnot start suing the other parent in federal courts and state courts. And such an argument was thrown out by the Vermont Supreme Court that as long as the elements of the cause of action are met, the controversy or the case must proceed to a jury trial. You can't throw a case out on pure speculation that allowing a case to go forward might just open floods of litigation here. On a similar note, another case out of Arizona, Pancratz versus Willis, where the plaintiff father had not seen his daughter for 4 years because the mom alienated and kept the child away from the father. The case proceeded to a jury trial where the jury awarded the father $125,000 in compensatory damages, and the appellate court affirmed the award. Then we have a different category outside of the IIED, a different category of lawsuits that concern interference with custody and visitation. And these are the lawsuits against alienating parents and their enablers, the third parties, family members, aunts, uncles, grandparents, stepfather, stepmother, school teachers, neighbors, whoever assists the alienating parent into continuing that conspiracy, continuing their actions, the wrongdoing. They could be part of the lawsuit, could be a defendant as well, apart from the alienating parent. Take a look at the case Wolf versus Wolf out of Iowa, Supreme Court, 2005. In this situation, the parties had divorced way back in 1999, and the custody was given to the mother initially. Thereafter, the custody switched back between the father and mother, and finally, the father ended up with custody, but the mom continued to keep the child away from the father in the state of Arizona, disregarding the Iowa court's custody order and decision, and stayed there for the next 11 months, despite the clear custody order to the contrary. Ultimately, the father filed a civil lawsuit in the Iowa courts for interference with custody, based upon the Iowa's family court decision. And the appellate court affirmed the award to the father for compensatory damages and punitive damages as well. Another horrific case is a case by the title of Streeter versus Executive Jet Management, arising out of Connecticut in 2005. This is a case where a father absconded with the two children, ages 6 and 7, from Connecticut to Egypt via a private charter plane without the mother's knowledge or consent. Basically, a parental abduction, kidnapping. The children were recovered after 22 months from Cuba. During this time, the mother was able to speak with them by phone on an irregular basis. Fortunately for the mother in this case, her family had money to spend. They spent millions of dollars in the recovery efforts, both in the U.S. and internationally, including trips to Egypt, Turkey, Cuba, New York, London, Houston, Washington, D.C., to explore every lead and to eventually find the kids and to obtain sole custody of the children in an Egyptian court. Finally, the kids were recovered in Cuba, and they demonstrated signs of severe alienation and severe mental health issues, pathological behaviors. The kids were filthy. They screamed at their mother. They kicked her. They bit her. They shouted obscenities. And they were in a very precarious emotional situation. They had to go through massive mental health intervention, therapeutic efforts, and finally the mother and the children sued the air charter service for interference with custodial relations, negligence, loss of filial consortium. They demonstrated how the private airline company, the private jet, was thoroughly negligent or willfully blind to every sign that was there that the father was kidnapping the kids did not have a notarized letter from the mother. There were several red flags that this was the case of parental kidnapping with the airline ignored. And it went to a jury trial. And the jury awarded the mother and the children $10 million for emotional distress and $17 million for the loss of filial consortium. And was appealed. The appellate court affirmed the jury award. In a somewhat different case out of Wisconsin, Lloyd versus Loeffler, the Seventh Circuit affirmed the district court's judgment against maternal grandparents for their role in interference with the father's custody. The father had been awarded custody of the child in the state of Maryland, and the mother had visitation rights. But grandparents, together with the mother, conspired to keep the kids away from the father and continued to alienate them. And the court awarded $70,000 in compensatory damages for which the grandparents were jointly and severally liable, $25,000 in punitive damages, and the court ruled that the damages will grow by $2,000 every month until the kid is returned to the father's custody. A similar case out of New Jersey, the Ruggiero versus Rogers, where alienation and kidnapping issues, and the lawsuit was brought in a federal jurisdiction alleging violation of Parental Kidnapping Protection Act. And when the dust settled after litigation, the appellate court ruled that an allegation of deliberate interference with the legal right of a spouse to custody of a minor child is a tort, a viable tort under New Jersey law. Eberly versus Adams, Texas, where parents sued for interference with the custodial and parenting rights and won $1 million plus in actual damages and punitive actions. Let's talk about lawsuit against judges. When suing a judge, whether a federal judge or a state judge, there are two major roadblocks that a plaintiff faces. One is judicial immunity. The well-established doctrine of absolute judicial immunity shields a judge who is performing his duties from lawsuits and judgments for monetary damages. And this doctrine comes from the belief that a judge should be able to act freely upon his or her convictions without threat of lawsuit for damages. That while discharging his duties, a judge should not be worried about whether he or she is going to be sued for anything, even negligence. That being said, it is equally true that judicial immunity is not absolute. It is not limitless. And there are two exceptions to judicial immunity. One, a judge is not immune from liability for non-judicial actions, that is, actions not taken in the judge's judicial capacity. And two, a judge is not immune for actions, even though judicial in nature, if those actions were taken in complete absence of all jurisdictions. If we unpack the first exception, that the judge is not immune from liability for non-judicial actions, this exception turns on the nature of the act itself, whether the function that is complained of, is it normally performed by a judge? And two, the expectation of the parties, whether the parties expected or should have expected that they were dealing with a judge in his or her judicial capacity. So, for instance, when a judge stops being a neutral arbiter of disputes, but instead becomes a prosecutor or an advocate for a party, he or she would lose the cloak of immunity. a judge must not abandon his proper role and assume that of an advocate. The other roadblock in suing judges is the doctrine of sovereign immunity, or the 11th Amendment, which the Supreme Court interprets as a protection for states against the federal courts and agencies. A state agency or department is characterized as an arm of the state and is also entitled to immunity from suit under the 11th Amendment. So, for example, a state court judge can't be sued in a federal court if the state ultimately were liable for damages. But there is a difference between an entity such as a city or a municipality, and if we have a city judge or a municipal entity who is liable for ultimate damages, then the sovereign immunity may not apply. And also the judicial immunity attaches to judicial acts, where the acts in questions are ministerial rather than judicial. There is no judicial immunity. For example, the issuance of marriage license, even though done by a judge, is a ministerial act. And refusing to do that in violation of plain black letter law could result into a lawsuit for money damages where no judicial immunity could attach to the judge. Take a look at the case of Kirkland versus DeLeo out of the Third Federal Circuit. Here, a municipal court judge conducted a criminal trial without a prosecutor or a defense counsel, personally conducted direct examination of the testifying arresting officer, and questioned one defendant at length about the conduct at issue. And the court ultimately held that the judge's actions went beyond legal error, that the judge was no longer functioning in his judicial capacity, that being a prosecutor and taking on the case and getting involved in the case instead of being a neutral arbiter of dispute, he was not entitled to judicial immunity at the pleading stage. Another case was Kowalski versus Bolliker out of Chicago in the Federal Seventh Circuit, where the husband sued an Illinois judge and accused her of engaging in extrajudicial efforts designed to prejudice the state court against him and in favor of his ex-wife, who was the judge's best friend. The husband accused the judge of writing letters to the other judge who had the case of divorce in front of him. And the judge who wrote the letters had no authority to do so. She was interfering. She was the wife's friend. She was acting as an advocate for the ex-wife. And that judge's alleged interference in the divorce proceedings was a non-judicial act. She was not entitled to judicial immunity from the husband's federal lawsuit and became ultimately a potential witness in the divorce case. The immunity was denied. The other case out of Michigan is Ratte versus Corrigan, where a Michigan state court judge acting administratively was denied absolute judicial immunity because of pre-signed forms that the judge had made available, which allowed the Department of Homeland Security and the protective services to remove the children from parents without due process, without a hearing. And in fact, it was a policy that the judge had put in place where these pre-signed forms were made available to state actors who could use these forms and that institute removal proceedings without any checks or balances. And that judge was denied immunity and the case was allowed to go forward. Guardians ad litem are also provided immunity, but they are typically given qualified immunity, which is seen as a quasi-judicial immunity, since they act as an arm of the court. But again, where a GAL is not acting within his statutory duties, he is not acting as an arm of the court and cannot be entitled to quasi-judicial immunity. Let's take a look at a case out of Washington, state of Washington, Kelly versus Pierce City. Here, a guardian ad litem was sued and was denied immunity because the guardian went beyond his statutory duties and overstepped the role and, in fact, abused the role of the GAL. He began sexually harassing the mother, assaulted the mother, repeatedly asked her to go out on dates with him, did no investigation about the child, made several sexual overtures to their mother, and suggested the mother find some way to pay him back for favorable custodial decisions or opinions, sent pictures to her and whatnot, and ultimately when the lawsuit was filed, he had the audacity to claim immunity, which was denied. And it was held that the GL was clearly not acting within the GL's function and the role when doing these things. Another case was Abolafia versus Reeves out of Idaho, where absolute quasi-immunity was denied to GL, who decided to appeal the order of his termination. In this unique situation, the parties agreed that the GL should be removed. The judge removed the GL, and the GL appealed that order of removal, forgetting that the usual rule, the rule of the thumb, is that the guardian ad litem serves at the pleasure of the judge. And not only the appeal was lost, but the appellate court awarded the fees, attorney fees and costs, to the parties, the parents who had to defend this appeal, and the GL claimed immunity against the fees and was denied such an immunity. There are other cases, Runyon versus Zacharias, Tennessee case, where a guardian ad litem was sued by the minor child after the child got the age of majority and was allowed to go forward against the GAL. However, the case was dismissed because the grounds of the duties, obligation that the GL had, which was to the court, not to the child, to protect the confidences, if revealing the confidences was what was necessary in order to protect the best interests of the child. So, in a nutshell, there are avenues to bring actions in tort against the state actors, against judges, against therapists, against guardians ad litem, and other professionals. But these cases have to be weighed very carefully before bringing them on. In fact, majority of these cases are often dismissed by the trial courts before they go to a jury trial. Sometimes it's done because the complaint fails to state a claim. Sometimes it's done because of the grant of immunity to the judge or the guardian ad litem, absolute or qualified immunity. Sometimes it's dismissed because there is no evidence after discovery that would allow the claim to go to a jury trial. But if the facts do demonstrate a viable claim, it could be intentional interference with the intentional infliction of emotional distress, or it could be defamation, or it could be a civil conspiracy, then those cases have proceeded to jury trial, and the juries have awarded damages for behaviors that have been considered to be outrageous. And severe parental alienation has been seen as outrageous conduct that would fall within the umbrella of a tort of IIED. But going back to my initial analogy of spectrum of remedies, these lawsuits are more of exceptions rather than the rule. It's far better to take a case and make a case of alienation before the court to ensure that your lawyer presents a case before the judge, lays out the facts of alienation, gets together the expert evidence necessary to present a case of alienation and seek the appropriate intervention. The reason so many of these cases go wrong and result in the horrific situation is because of inaction on the part of targeted parents' lawyers, or refusal to go to trial, or failure to go to a trial, and rather just waste time and spend money in useless motion filing, or wasting time in going through traditional psychotherapy, which makes the situation far worse. And it's not uncommon to see targeted parents advised to agree to a cooling off period. There are cases where a targeted parent is advised by their own lawyers and the guardian ad litem to sign off on suspension of parenting time, or to agree that he or she is not going to enforce the parenting time orders to allow a so-called cooling off period, to allow the children a room to breathe, to not force them, and thereby somehow the kids are going to see that the targeted parents is reasonable, and then they'll come around and everything will be just fine, sunshine and rainbows. It never happens. In most situations, the kids get further entrenched, and the targeted parent is simply asked to give, and give some more. And then you have this frustration on the part of the lawyers, the judges, the guardian ad litem as to why is the case not moving forward. And they try to look for a scapegoat. Often the therapist changes. Sometimes the GAL changes. Sometimes the judge just kicks the case up to another judge and recuses himself or herself for whatever reason. But anything and everything is done except going to trial and making a finding of facts, which is what's required in these cases. So there are various ways to hold professionals accountable. Filing the motions before the court, seeking sanctions and attorney fees is also one of them. If you have repeated violations of parenting time orders, for example, start asking for contempt citations. Start asking for attorney fees. You might not get it the first time, but when you file motion number 3, motion number 4, motion number 5, seeking sanctions, attorney fees, and costs for violation of parenting time, pretty soon the family court judges will get the message. There used to be a judge in Chicago, Judge Michelle Lawrence, who wrote a chapter called Judicial Perspectives on Parental Alienation. And Judge Lawrence talked about that in her 17 years on the bench as a family court judge in Chicago, she learned that alienators don't get the message unless there are consequences for their actions. That it's never helpful for a family court judge to give a little speech from the bench and expect the alienators to get it or to change their behaviors. The only reason, the only way an alienating parent is going to change the behavior is only if their actions have consequences. If the violation of parenting time results into the makeup time for the targeted parent, immediate makeup time. If the second violation results into not just makeup time, but additional reparative time for the targeted parent and financial sanctions. If every violation further is going to cost an alienating parent X thousands of dollars for attorney fees and costs. We have had judges who have been extremely sensitive to the violation of parenting time, and at the first instance of violation, they call the attorneys into the court together with the parties and make it clear that any future violations of parenting time or any unilateral decisions to hold the children back will result in the court issuing sanctions. And repeated violations will also result in the court taking a good hard look as to whether there needs to be a modification of custody. And in these situations, the alienating parents get a message. These cases don't end up in the nightmarish cases because these judges know what it takes to do these cases and how to handle the case of alienation. The cases that become nightmarish situations where children start screaming, refusing to go on parenting time, police are involved, CPS is involved, guardians and litems are involved and whatnot, are those cases where the courts refuse to make a decision, where the lawyers refuse to make a record, where people are not held accountable, where actions go without unpunished. There are no consequences. Those are the cases where it goes to hell in a handbasket. And it's important, that's why, to make a proper record. Record is what your case is about. Unless something is part of your court record, it doesn't exist. I'm taking a look at my notes. I think I've covered everything. We have about 4 minutes left to go, and I'm seeing if there are any other questions that I need to answer. Most of the questions were also about how to get a judge to rule the relief that you're asking for. And it depends upon the case. I mean, if you are presenting a case of alienation and you are using the 5-factor model to demonstrate to a judge as to why alienation exists, then after a hearing, it will be pretty hard for a judge to ignore that. Of course, you have to go through the extra mile, and you have to explain to the court as to why it would be a mistake to not fall into one of the pitfalls or be susceptible to the fallacies out there, such as if the child is 16 or older, you can't really tell the child what to do. Well, no, the research demonstrates otherwise. We have had programs such as Linda Gottlieb's program of Turning Points for Families, which have terrific success outcomes, family bridges as well. And these programs have had older children, 16, 17, even older, and they've got great results. But the judge needs to understand that. The judge needs to be explained as to what happens in these programs. How are we going to get the child to a program? What happens on day 1? What happens on day 2? Why is the no contact period necessary? It's not simply enough to file a motion without supporting affidavits, without supporting expert reports, and expect the judge to rule and give you a program or give you the relief that you need without holding an evidentiary hearing. It never happens. A trial judge needs to hold an evidentiary hearing to make a finding of facts. And it needs to be done that would be sustained at the appellate level. You don't want a trial court to give you an order only for it to be overturned quickly by a court of appeals for lack of evidence. And that's why it's a step-by-step approach. And you need to approach it in that fashion. I think we are doing good on time. Elaine, I'm 2 minutes early, and I'm giving it back to you.